Hello, 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 everyone.
In trouble. Y'all said he just does not.
A lot of you niggas gonna be cheap.
Yay, I'm on. Hi, Jamie. Okay, y'all. So I believe I'm currently streaming from YouTube and TikTok. But I'm trying to confirm because this is my first time going live on YouTube. So, oh, you know what? Yes. So I see. I just got an email that I'm live on YouTube as well. Yay. Hey, Shar. Okay, perfect. Shar, are you watching from TikTok or YouTube? Okay, TikTok. All right. So I'll be honest with y'all, I don't have that many subscribers on YouTube yet, so I'm not expecting a bunch of people, but I am invested in doing this consistently on both. So, hi Eva. So, yeah, I'm live on both. So I'm gonna give myself a second just to figure out what I'm looking at. It looks a little strange from my side. Nothing yet. We haven't talked about anything yet, Nikki, but I do have some updates. All right, so okay. All right, in a perfect world, I'm gonna get my YouTube updates and comments at the same time as I get the TikTok ones. That's not happening right now. So if you are watching from YouTube, my apologies. I really and truly apologize. But I can't see anything you're saying. So you know what I'm going to do? Hey, Mom. I'm going to go to my YouTube on my phone. And let's see. But yeah, I have updates. Are you guys able? Yes, we are just getting started. Just getting started, Jerica. Yep, Shard, that's what I want to talk about. So I thought I was going to have one update today. Shout out to Jamie for sending me both. Turns out we got two updates. There was not only a new motion to recuse filed yesterday, but Judge Krause already denied it today. So I'm going to just go through both. I just want to give people a couple, minutes to get in. Thank you. I see I have gifts. I now know that means that translates into money at some point. So I appreciate it. Yeah, she moves very quickly, quicker than I thought. But I don't necessarily think this is the end. It's very stressful. It's very stressful. Very stressful. Okay, first of all, let me make sure I'm hydrated, y'all. But yeah, so we're going to start with Brian Steele's motion to recuse Judge Krause based on some financial things, some donations to election campaigns. Let's start there, but y'all, I get thirsty dehydrated very quickly, so I need to make sure I'm hydrated. Y'all forgive me. In a perfect world, I would have done this already. Jamie, the way I'm very proud of the way that I have balanced life today, because there's a lot to do for my own clients, but yeah. Hi, Jada. No double jeopardy yet. We are not at risk of double jeopardy. Hi, Sarah. Hi, Sierra. Hi, Chris, Karen, Kelly, Siren, Dawn, Cheryl. All right. So it's been about 5 minutes. Thank you, Jamie. Y'all, listen, as much as I talk to myself about this, not like House of Dragon. You did not miss anything. I am about to start going over this first motion. So just recap generally what's going on. I'm sure everybody on this live probably already knows about the ex parte meeting. All the stuff that is happening right now stems from this ex parte meeting. In short, Kenneth Copeland, aka Woody, took the stand finally after being discussed a lot in this trial. When he took the stand, he pled the fifth. As a result of that, he was given immunity, forced immunity, if you will. He did not ask for it. He did not negotiate it. It was forced upon him, and that meant that he could not plead the fifth. As a result of him attempting to plead the fifth anyway, he was arrested and held in contempt. The only way that he could purge himself of the contempt, purge meaning remove the contempt, is if he testified. And I guess in an effort to, let me use the right word, persuade or convince or explain his circumstances, the state attorney and the judge had a meeting with him alone without the defense attorneys. That kind of snowballed into a whole, I don't even know how to, it snowballed into a lot. So we've had, I don't know, maybe 10, 15 motions at this point. And where we are now is Brian Steele and Keith Adams, who represent Young Thug, and then Doug Weinstein, who represents Diamante Kendrick, have filed multiple motions to recuse Judge Glanville. Lord, it's almost, it's too cumbersome to kind of break down. So some of those motions are still outstanding, but one of the motions, well, let's take a step back. One of the things that Judge Glanville was doing was kind of just refusing to have the motion heard by saying that it was insufficient. He was also refusing to release a transcript and give more details about this meeting. Since then, Doug Weinstein sent a motion to the Supreme Court, who put in writing in an order that it had to be heard by a different judge. So we are now having it heard by a different judge. So the status that we're in now is the motions to recuse are being heard by a different judge. I hear a lot of confusion about whether or not this new judge, Judge Krause, is the new judge on the case. She is not. Judge Glanville is still the judge on this case until he is recused. He has not been recused. The only thing that's happening is all these motions to recuse are being heard by another judge. That's where we are. We are all invested, Kelly. It's crazy. It's really crazy. So that's where we are now. These motions have to be heard. So we have a motion to recuse. All of them kind of stem from this meeting, but they also have some other things in them that were happening throughout the trial. No, I did not get any notification that the state has responded. So at least one judge who was assigned this case randomly, which is what the Supreme Court said had to happen, she already recused herself. Another judge, Judge Krause, is currently set to hear these motions. That judge required that the state put a response in writing. Now, the state has not put that response in writing, and they asked for a 48-hour extension, which is not really uncommon. I know it's frustrating. It's frustrating for everybody, even me, and I'm an attorney, and I ask for extensions all the time. But it's not uncommon. So 48 hours is fine, and it's their first time asking. Now, I suspect if they ask again, it'll probably be a problem. I could imagine. So, yeah, that's where we are now. After after Brian Steele and Keith Adams filed their original, we'll call it the original motion to recuse Judge Glanville, they filed a supplemental motion to recuse, which is just additional information or additional grounds on why Judge Glanville should recuse himself. And that's the first motion that we're going to read. Okay? Let's see. So, we're going to start with that motion. Are y'all able to see the motion on my screen? All right, perfect. All right. And do I have anybody that's watching from YouTube? I'm really wondering. Yes, Jerica and Jada, y'all are watching from YouTube, or y'all can see the motion. All right. Okay, perfect. All right, so let's get started. So this is Brian Steele and Keith Adams' supplemental motion to recuse Judge Glanville. Now listen, I have not read more than the first page, and I was immediately taken aback. I personally, I like to consider myself a sharp writer. When I write motions, I like them to be passionate. I like them to be aggressive. I like the person that is reading them to know what I'm feeling while I'm writing it. There's a fine line between that and, listen, Jamie, the footnotes took me out. There's a fine line between that style writing and just being overly aggressive, right? But you want to be a strong advocate in your motions, no different than you are when you advocate in person in court. So I'm just going to read what I wanted to title this live. Undersigned counsel, this is footnote number 3. Undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done though the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members of the bar. Now listen, we are all biased. We are. It's just life is human nature. So calling somebody biased is not that big of a deal. But calling somebody unethical in writing is like, it's very aggressive. Saying they are unethical, there's plenty of ways you can say that to toe around with it. You know, this behavior was unethical, but calling a person unethical, I ain't gonna lie, y'all. When I read it, I was like, aggressive. But Brian Steele is basically saying, listen, it's unfortunate that, you know, people we hold in high regard, people in public, people that are public figures, judges, it's unfortunate to watch something like this happen where the trust in our justice system, I don't know how many of y'all trust the justice system, but I don't. But where, you know, the reverence that we have for what happens in the courtroom is kind of dismantled in this. That's unfortunate, but so be it. So be it. Brian still saying burn it all down. I don't give a damn. Burn it down. So yeah. Alright, so comes now Jeffrey Williams, by and through the undersigned counsel, and hereby timely files a supplement to motion to recuse Judge Glanville in the above referenced case. In support of this motion, Mr. Williams shows as follows. This supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, is timely filed as Uniform Superior Court Rule 25.1 mandates that the time for filing a motion to recuse shall not be later than 5 days after the affiant first learned of the grounds. Now, going back to these footnotes, there's a couple within the top. First of all, let's go back. The footnotes are at the top. Listen. The footnotes are at the title of the motion, y'all. That is very aggressive. He is saying, before I say a fucking word, there's some things that I need to get off my chest. Before I even say who I am, there's things that I need to get off my chest. It's very aggressive to put footnotes in a title. But I love it. I love it. All right, so first footnote, this motion applies to lawyers' love. And, oh God, he's not even calling them honorable prosecutor. He's not even, listen, y'all heard him early on in this trial. The honorable such and such in the court and this and this and that. He's not even, listen, Kelly. And you've been a paralegal longer than I've been a lawyer. So you have probably seen much more than I have. And I have never seen. This is crazy. But all right. This motion applies to lawyers Love and Hilton, in addition to Judge Glanville, as all three are material witnesses in the case at bar and will be called by Mr. Williams during the trial to show judicial and prosecutorial misconduct. So he said this already. It's not really new. He already said he was going to call them as witnesses. If I'm not mistaken, he's already listed them as defense witnesses. So he's dead serious about calling them as witnesses. It just kind of, it is what it is. Why is he calling them as witnesses? Because honestly, they've made themselves witnesses by participating in matters that go to the credibility of this prosecution, the credibility of them, the credibility of the witnesses. For example, the ex parte meeting. What he said in the ex parte meeting, asking questions about what happens if I lie, what if I say I committed this crime, what can I be prosecuted for? I already told y'all I lied. These are all things that he should be asked on cross-examination, and they were all witnesses to them. So, yeah, there's that. So, all right, footnote 2. This motion also timely moves to recuse the Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to her campaign. Also in April 2024, Judge Krause donated $500 to Judge Glanville's re-election campaign. Mr. Williams' trial has been ongoing since January 4th, 2023, which essentially means that this all happened while they were in trial. I'll tell y'all right now, before we even get to it, Judge Krause said, so what? She pretty much said, so what? Who cares? Yeah, so that's the basis for his motion. So going back to the actual motion. It shall not be later than 5 days after the affiant first learned of the grounds for disqualifications. And now this basically just goes through why it's timely. We don't really need to read that. But he's saying it's timely filed. It's also been timely presented to the Honorable Judge Krause and Judge Glanville on Monday, July 8th. In the case at bar, Judge Glanville's ex parte communications with a sworn witness, his counsel, lawyers Love and Hilton, and other representatives with the Fulton County District Attorney's Office are seemingly only partially captured by the court reporter. All right. That's not really groundbreaking. Wait, JD said they amended the motion? Ooh, I don't have the amended motion. What does it say? What is it, like different numbers? Oh, that she didn't donate to him? Oh, okay. All right. Honestly, that kind of, does it really change their argument? Not really. Not really. Just him to her, which I don't know if that makes it better. I don't know if that makes it better, but okay. So, all right, this whole it's only partially captured by the court reporter. Now, it felt a little, sexy for him to say that, but I don't really know if it is that sexy. It's obvious in the transcript that there were times that he, thank you, Maisha. There were times that he was off record, right? That they were all off record. There was, a time where he was talking to Kayla Bumpus. there was a time where they were just off record when Ms. Love left. So it's not really surprising that not everything is captured in the transcript, but it's important because it goes to the fact that had we been present, we wouldn't need, the transcript can't give us everything that we need because we weren't there for what happened in our presence but not on the record. As opposed to if it happened in the courtroom, if this was going on while we were in the courtroom, it wouldn't matter whether or not it was on record or not because we would all be witnesses to it. So that's really what he's trying to say. Yeah, Woody said it wasn't the full transcript. Kayla Bumpus didn't really say it wasn't the full transcript. She kind of just said, well, I don't really remember it. It doesn't seem like it's the full transcript, but she wasn't super clear in like the accusation. So, but Woody definitely said it wasn't. He absolutely said it wasn't. All right. Okay, so Judge Glanville, Lawyer Love, and Lawyer Hilton. I ain't gonna lie, the fact that he keeps saying Lawyer Love and Lawyer Hilton is kind of, I don't know. It's just something. It's so different than the way he was describing them and talking about them initially. Judge Glanville, Lawyer Love, and Lawyer Hilton have prejudiced and tainted Mr. Williams' trial so deeply, as Judge Glanville has not acted as judge but morphed into an essential part of the prosecution team. And sometimes when lawyers write motions, they will use certain phrases that kind of mirror things that cases have said and terms and standards that cases have discussed. That sounds like something that I've read even in Florida cases, that the judge or the bench has essentially become a part of the prosecution team, or vice versa. The prosecution could be making the same arguments, if this were an issue with the defense. But it sounds like he's mirroring maybe even this case, Johnson v. State, but I haven't read it. The judge's conduct, including the ex parte communication with the prosecutor during trial, resulted in the appearance of bias requiring reversal of the convictions and sentences. This is essentially a description of what happened in this Johnson case. And he's saying that this is exactly what's going on here, that even if the judge is not actually biased, that his behavior gives us the appearance of bias. And there's really no way to, avoid that. What do I think about Kayla going live with Woody? Do I think it's unprofessional? So here's the thing. Kayla, this is a very strange situation. Not strange, but just not normal. Because she's not his attorney in this. She's represented him before. They know each other professionally and possibly even personally, from my understanding. But they know each other. And she was not representing him at all. She was doing another attorney a favor. And that's how she got involved in this and did her best to quickly get uninvolved in it. Unfortunately, her role in the case kind of it became sensationalized real quick. And so did Woody's, even more than it already was. But now I'll say this. Me personally, I wouldn't be. And I'll say, let me take a step back and even say this. She did not kind of make any real statements or go into any real detail until, I believe, after she was cleared by Judge Glanville, after he said that he wouldn't go forward. But, right. So apparently Kayla's brother, I think, is married or dating Young Thug's sister, is my understanding. Thank you, Jamie. But yeah, so they know each other, and she's also from Atlanta, so she might just know him, quite frankly, just from being from Atlanta. But I personally wouldn't have done it because it just feels too messy. Like, once you get somebody on live, it's hard to control what they say. As his attorney, current, prior, future, present, whatever you want to call it, I wouldn't want to risk him saying anything that could potentially get himself in trouble. But then again, he has immunity. So it's just, honestly, it's messy. Me personally, I probably wouldn't have done it. But we also live in the age of, technology, social media. Attorneys like myself are on social media. And this was a really good opportunity for her to kind of throw herself out there. And I think she's using that and maximizing it. Maybe I wouldn't have done it the exact same way, but I won't say that it was unprofessional or wrong. I personally wouldn't have. Not while he was still sworn. He's still sworn. He's still a sworn witness. But also, once, in a week or so, we may not even be talking about this anymore. So, I don't know. Yeah, she did. She said, we're not going to talk about the case, but once it comes up, people start asking questions. Can you really control what is being said? I don't necessarily think you can. I would feel very uncomfortable being on live, but again, she doesn't represent him, and he's not being prosecuted. Let's also remember that. He's not a defendant in this case. He is a witness who has immunity. He's certainly free to say whatever he wants to say. He's not under any restrictions, but somebody who was afraid or worried about being prosecuted, who pled the fifth, I would think will want to be extremely careful and make sure that they, don't put themselves in any harm's way. But yes, she is. She is getting that social media coin. I don't blame her. I don't blame her for that at all. So neither one of them were dismissed. He just kind of said, I'm not pursuing them, kind of. I don't think he really dismissed them. I didn't hear it that way. I didn't hear him say that. It didn't sound like he was dismissing it to me. But maybe I'm tripping. Maybe I am tripping. But yeah. So that's that. Now, let's see. Okay. Alright, so USCR 4.1 mandates that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Yet Judge Glanville participated in these ex parte communications and then somehow attempted to keep them secret, I think he meant, by referring to the meeting as privileged and describing the improper secrecy as sacrosanct, which we all heard him say. And then he attaches a transcript. So this motion itself, I think, is like 20-something pages. The whole packet is 233 pages. Judge Glanville has totally abandoned his role as judge and has become prosecutor with Mr. Williams. Now, here's against Mr. Williams. That is a little hyperbole, right? But that is our job. And I don't know that there's an in-between. Like, I think that once you go to the left or to the right of being in the middle, you're there. So it's a little hyperbolic, but his point is, and I don't think it's just about the ex parte meeting. I think it's about some of the rulings that we hear throughout, this case. He's basically saying, look, the judge is a prosecutor at this point. The judge is a prosecutor. But yeah, so ex parte communications are presumed to be harmful by error, and any conviction and sentence will be reversed unless the state proves the error was harmless. Let's see. Mr. Williams timely raised his objections. We don't need to read that. Blah, blah, blah. We'll skip through all of that because this is all basically going back through the ex parte, all the things that they've already argued, which we know what they are. Now, getting into the meat of it. Judges, and we're starting at number 8, judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. That is the standard. Whether or not it might reasonably be questioned. So what we're asking is, Judge Krause, can we say that her impartiality might reasonably be questioned by this donation? And that's not the only reason he's asking her to be recused, but might it be questioned by this donation? Including cases in which the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings, maybe code. Maybe he wrote that wrong, but the proceedings, Code of Judicial Conduct, Rule 2.11, Judge Glanville has been derelict in his judicial duties and must be recused. So we're still talking about Judge Glanville. Once evidence of this illegal ex parte Star Chamber meeting was revealed by undersigned counsel in the afternoon of June 10, 2024 in open court, lawyers Hilton and Love sat mute sat mute while Judge Glanville found undersigned counsel in contempt of court and sentenced undersigned counsel to the longest possible time in jail for unmasking Judge Glanville's, lawyer Love's, and lawyer Hilton's improper, illegal, and unethical conduct. Judge Glanville must be recused from any further action on Mr. Williams. Not derelict. Listen, I love a good literary read. And I mean read in the literal way and the figurative way. Derelict, yeah. So it's important that the way that Love and Hilton responded are also important, right? Because it shows that they're all on the same page, right? It shows that all of them are on the same page. So I've been in a courtroom where even the prosecutor is like, whoa, judge, just so you know, we are not asking that this attorney be held in contempt. We are not asking that this person be held in contempt. But the fact that he's held in contempt because he won't disclose while the prosecutor who asked for the meeting is quiet, that does, it gives that it's a team effort is what it gives. Yeah, I think they knew it was wrong, but by the time this all happened, they all hate each other. They all been calling each other liars. If I were Miss Love, I don't know that I would have been speaking up for Brian Steele either. But yeah, they all hated each other by this point. Maybe not Miss Hilton. Maybe not. Because I don't think there was anything negative said about her up until that point. But yeah, he makes a really good point. They all sat in here while I was held in contempt for addressing a meeting that they had no business having. And here's another big point that I wanted to discuss the last time. When Miss Love was explaining why the meeting was had, I don't know if y'all remember that. Miss Love, because, you know, she had to say something on the day that this was all happening. She said that the meeting, that there was no issue with the ex parte meeting because they had no standing, because the defense had no standing, because it was a civil contempt issue, and so they didn't have to invite them to the meeting. I'm hoping that they paid close attention to that, because they said nothing about, I don't believe, correct me if I'm wrong, anybody that was watching, I don't believe that at the time that it was discussed that they mentioned anything about fear, about him being afraid, right? Because the whole point is, now Judge Glanville is saying, well, this meeting was fine because the witness had some sort of fear. This is one of the exceptions for an ex parte meeting, if the witness is in fear. And if the person that they're afraid of is the defendant, right? That, other than the assumptions and the suggestions that Ms. Love made in general, that has never come up. Woody, for damn sure, has never said he was afraid, right? But yeah, she sat there a long time quiet. But when she did get up, she said, Judge, we didn't have to invite them. This is a civil contempt issue. She did not address that it was a critical stage. She did not address that it was sworn. She just said it was a civil contempt issue. So I'm really interested in seeing how she responds and what she says about whether or not they were entitled to be at this meeting when it's responded to in writing. I'm really interested in that, because everything that Judge Glanville said is Monday morning quarterbacking. Everything that he said now are all things that he got an opportunity to argue because of the delay that he caused by not pulling out this transcript. Okay, hold on. Hold on, y'all. Alright. Okay. Hold on, I'm trying to go back through the chat. The difference between civil and criminal contempt. The easiest way I can explain it is basically civil contempt gives you an opportunity to correct the behavior. It's kind of like an ongoing behavior that can be corrected, if that makes sense. But criminal contempt is something that was done that cannot be fixed. It cannot be undone. There's no way you can correct it. It's just something bad that you've done. There's also a bunch of differences in how they can be punished, etc., etc. But for the most part, you're dealing with a civil contempt issue when the judge or the prosecutor or somebody is trying to get you to do something, and you won't do it, or you've done something that you need to reverse. Criminal contempt is you did something that just was done. It was just bad behavior. You cussed out loud. You cussed at the judge. You called the judge the curse word. You did something that, or some of the jurors, I think, were potentially held in criminal contempt, right? Like, you didn't show up to court one day. There's no way to really correct that because you already didn't show up. Court already happened. It was already done. That's kind of it. So love should be held in civil contempt. You mean for what? Contempt for lawyers is very, 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 very rare. It is not common at all. For being sneaky. Jamie. For being sneaky. That is funny. That is funny. Yeah, it's rare though. It's rare. Okay. All right, let's go back to this motion. All right, the reference sections of the Georgia Code of Judicial Conduct are meant to be self-enforcing, and it's the judge's duty to disqualify himself as soon as he is aware that the grounds exist. Now, this is the other thing. I've probably, I want to say maybe filed like 2 or 3 motions to recuse. Maybe not even that many. Maybe 2. I'm going to say 2. And I actually have never had to have a, I don't take motions to recuse lightly. So I don't think I've ever filed one where it was, I think it was serious every time I filed it. But I haven't had to have a hearing. Not one where, another judge has to hear. Generally, if the grounds exist, the judge should recuse themselves. They should disqualify themselves without it going this far, but yeah. But that's what he's basically saying. Like, it shouldn't even go this far. The judge should disqualify himself. All right, these are all citations. Blah, blah, blah. All right, in this case at hand, the state cannot show the Judge Glanville's lawyer. The Judge Glanville's lawyer Love's and or lawyer Hilton's intentional and willful complicity in these ex parte communications was harmless error. As shown in Exhibit B, the improper influence and interjections by Judge Glanville and his 2 cohorts. Brian's still so shady. Y'all, why would he call Judge Glanville and the 2 prosecutors cohorts? Why would he say that? Why would he say that, y'all? Was he too prideful? He was way too prideful. Yes. Maybe it was other things too. Maybe he really felt, I always like to leave room for the fact that he was being genuine and he really felt that way. Yeah, I mean, at this point, like, these kind of cases can make, some of y'all already told me y'all watched the Darrell Brooks trial. The judge in that case was like, she was like an angel. She was like an angel, and it was really beneficial, I think, for her career as far as like publicity. She did so many interviews afterwards. Now I've seen at least 2 other trials that she's been over being streamed. So It's not impossible that, the exposure and the fact that he had already, think about how long this case has been going on and he's been on the case. I'm sure he also recognizes that if he is disqualified, the whole case goes away and it's going to have to start over if it starts over, and it's going to be expensive. So those are all considerations I'm sure that he's taking, but those should also be considerations that he's taking before you do things like have an ex parte meeting. That's my opinion. Since still, I am certain they probably already have lawyers. If I were Judge Glanville has probably already talked to lawyers. And if we get a new judge, does it restart? I can't imagine it won't. I can't imagine there's any lawyer, any judge that could hop in where we are. It would have to. There's no way. No way. All right. So back to the motion. Okay. So Judge Glanville and his two cohorts from the Fulton County District Attorney's Office on Mr. Copeland changed Mr. Copeland's his stance not to testify against Mr. Williams. That's important, right? Because if nothing else, he took the stand, pled the fifth. He was arrested before he got the opportunity to change his mind on his own or with the advice of his attorney. He meets with the judge and the prosecutors without the defense attorneys, and then he gets on the stand and miraculously he's testifying now. So it's not harmless error, which is what I'm sure the state is going to argue. It's not harmless error because before this meeting happened, he pled the fifth. And the testimony that he's giving now, I'm sure Brian Steele is going to argue some of it is harmful to Mr. Williams. So it's not harmless error because if he had continued to plead the fifth, whether it be, he go to jail or whatever it may be, but if he had continued to plead the fifth, that harmful testimony wouldn't have come out. So yeah, if Mr. Copeland refused to testify, all of his prior false inculpatory statements as to Mr. Williams would not come into evidence based on Mr. Williams' constitutional right to confrontation. Exactly what I just said. Intimidation tactics thrust upon Mr. Copeland by the combined work. Ooh, he's using a lot of collaboration words. Combined, cohorts, Lord. By the combined work of Judge Glanville, Lawyer Love, and Lawyer Hilton resulted in Mr. Copeland's decision to testify, and thus Mr. Williams has another witness to challenge at trial. All right. Moreover, ex parte communications are so disfavored and repugnant that even if the ex parte communication would be cumulative of other evidence introduced at trial, same would not be harmless error because the ex parte communications are presumed to be reversible errors. So, this is good anticipation by Brian Steele. Now, I'm sure if y'all have been watching, there's been a whole bunch of repetitive testimony, right? Different witnesses giving pretty much the same information from different perspectives about the same crimes. What Brian Steele is saying is, if the state tries to come back and say, oh, well, this whole the fact that he testified that they met up at a McDonald's, even though there's no video of them meeting up at a McDonald's, let's assume for this argument that there was. Let's not say there was no video. They don't have any video for whatever reason. But he's saying if there's other evidence that says the exact same thing that Woody is saying, the state can't use that to be like, oh, yeah, this was real bad, but it doesn't matter that it was real bad because it's not a big deal. Because we already had other witnesses that would have testified to the same thing. Brian Steele is saying, no, even if that's true, the law says an ex parte communication is automatically reversible error. It's automatically harmful just because it happened. And that's probably meant to discourage this kind of behavior. Does it completely restart? Completely restart. They're going to be asking for a mistrial and that it start over with new jurors and everything. Because how could they go forward in these and bring in a new judge? These jurors are going to be like, what happened? Where did the judge go? So yeah, it's gonna completely restart. Completely. Yep. All right. Okay, now where were we? All right, yeah, so even if there is other evidence, it's presumed to be reversible error. Mr. Williams' fundamental constitutional rights were trampled, ignored, and violated as a result of Judge Glanville's, Lawyer Love's, and Lawyer Hilton's improper, unethical ex parte meeting with witness Copeland. Moreover, the cover-up, secrecy, and silence of these three team members. Brian Steele. Y'all, this is so petty. Oh my God. Netflix should listen. I want to make sure if they do, y'all make sure y'all write them and tell them I need to be interviewed for this docu-series. But team members, Brian Steele is so petty, y'all. Oh my goodness. There is none, Jamie. There is none. This case is strung together by hearsay, lyrics, social media posts, people that have significant motive to lie and significant credibility issues. Have we seen any physical evidence? I don't think we've seen a tiny piece of physical evidence. Please correct me if I'm wrong. Yeah, I don't think there's been one piece of physical evidence entered at all. At all. Yeah, Ryan still is eating them up in this motion. Team members, cohorts, colleagues. Oh my God. Woo, Lord. The cover-up, secrecy, and silence of these three team members is unforgivable. To wit, after the Star Chamber meeting, the three, public officials, Lord, it's so shady. Oh my God, this is, okay, let me not make light of this, right? A lawyer speaking like this in emotion, this is a man who is fed up. He is saying he's saying, I'm letting loose on everything. There is no, no professional courtesy that I'm giving to these people. They don't deserve professional courtesy. That is what this is. That's how it reads. This kind of motion, it's not, it's not impossible. It's not unbelievable. It's kind of just shocking because it's so rare for something like this to happen in this way. He is fed up. He is fed up. The way this motion reads, like, I don't give a damn. This motion reads like, I don't care if I'm ever in your courtroom again. I don't care if I have a case against you, later on. I do not care. I don't care. Team members, Lord Jesus. These three public officials simply strolled into the courtroom, face the cameras. So shady. Simply strolled into the courtroom, faced the cameras, called for the jury, and feigned to continue trial as if nothing out of the ordinary occurred just hours, minutes before. And I can't lie. Is he being that shady? Did he link the time? And Lord, I don't want to click this link and see Miss Love literally strolling in, looking at the cameras. There was a couple times where she definitely looked at the cameras. But yeah, this is what I was talking about in my last video about how crazy it is that the defendants and the defense attorneys were literally sitting on the other. In most courtrooms, at least in Miami, the courtroom is the courtroom, and then y'all see how Judge Glanville exits kind of to the back. That's how it is in Miami. But right on the other side of that door that he's going out of in Miami, that's the judge's chambers. And there's normally like a back hallway where each courtroom, there's like essentially a back hallway to all the judges' chambers and whatnot. So each courtroom has that same kind of exit where the judge can go out. They can go into their chambers and they can walk through that back hallway to and from any courtroom. So the fact that he, assuming it's like Miami, there was one wall. There was like a wall, maybe two walls between this meeting and everyone else that's in the courtroom, and they all just sitting there twiddling their damn thumbs, not knowing what's going on. When it was as simple as just letting them know, and then they come in the courtroom and they want to start court. They were calling the jury out. Brian still had to say, excuse me, I need to say something. That's kind of crazy. Oh, hey, Juanita, are you still in Miami? Yeah, that's crazy. He definitely cited YouTube. I feel like if I click the link, it's gonna take me. Let's see.
Do you think strength is a
gift? I clicked the link, y'all.
It's
I
not.
I want to see what's the time.
Everything you've seen me do
42.
was.
Let's see. What's that? 2:35:42.
Mr. Copeland here, so go ahead, Miss Hilton.
Thank you.
Lord.
Okay, all right.
Y'all. Okay.
All right, ladies and gentlemen, we are back on the record.
All right, y'all. They definitely interacted like nothing happened. So he cited literally the moment that he cited the moment that I started at 2:28. He cited the moment that they came back into the courtroom, basically. And yeah, it's yikes. It gives yikes. It definitely gives yikes. Could you imagine? Like, I would be pissed off. I'll be pissed off if I went into the hallway, and whether it be Kayla Bumpus or, you know, whoever, I would be pissed off if I came into the courtroom, or I was sitting in the courtroom all that time, and then they, you know, walked in acting like nothing happened. Yeah, I'll be pissed off, quite frankly. Very. Let me see if I can put, hold on. Let me see if I can put the link.
Our session, the Chief Honorable Judge Gerald Glanville will preside.
Have I ever had to deal with a judge like this? Not like this. Not this specific type issue. I've dealt with judges that were disrespectful. I've dealt with judges that just because I was there, I've dealt with all kind of judges. Not this particular kind of issue. I've never seen. This is like a one of a kind issue. I've never seen. I've seen some crazy things. I think I told y'all, one of my really good friends, I was watching her in trial, and the defendant was malingering, pretending to be mentally ill, and he promised to God, took, I don't know how he got it, but he took shit and piss and tried to throw it on the judge in court. So I've seen crazy things happen, but this is one of a kind. This is definitely one of a kind. All right, back to the motion. Okay. Mr. Williams needs to examine Judge Glanville, Lawyer Hilton, Lawyer Love, and all the other members of their prosecution team. Ooh, he listed everybody. To reveal the date and time of every ex parte communication that occurred concerning Mr. Williams' case since its inception, the subject of same, and order the court reporter to produce any transcript of same and or unseal all documents from the potential improper ex parte communications. You know what? I'm not gonna lie. This is a really good point. We only know about this ex parte meeting. Now, ex parte meetings are not common, but they found out about this because someone leaked it. They don't know whether or not, you know, Judge Glanville or the state thinks that this is cool, this is okay. And remember, Woody is not the first person that was held in contempt, essentially, and arrested based on their testifying. If y'all remember, gosh, I forgot her name. The other one who, her mom passed away, and it was like an issue with her, and she felt like Miss Love was trying to intentionally, you know, bring harm upon her and talk about her mom. Arkellian Bennett, that's her name. Her. She was also arrested based on, you know, her not wanting to testify. So I don't think it's a bad point to bring up, like, how many other witnesses did you do this with? Especially when the state's point is this has nothing to do with the defense. It's clear the state does not think that these ex parte meetings are problematic at all. Because what they're saying is this is not a defense issue. This is not a criminal issue. This is about civil contempt. So, are they wrong? They're not wrong. Okay, Jamie, I see like a little thing that says, like a little purple thing that says 15 next to it. What is that? Y'all gotta help me out. I'm a millennial, but I don't be knowing. I felt bad for her. I felt really, really bad for her. Super duper bad for her. What are those 15 things? What is that 15 next to you? Brian Steele is not wrong. They're not wrong for Brian Steele and basically Keith Adams and Doug Weinstein. They're not wrong for saying, also, I want to be able to question them about how many other meetings they've had. Because based on what Ms. Love has said, she doesn't think that it's a problem. So, alright, I got to figure out what that means. I have no idea what that means, Jamie, but it's only on yours. I don't know. Okay, I'll figure it out another time. Listen, I'm sure, and Doug Weinstein said it, and I have said this over and over again, a good attorney is anticipating the other side's argument. Doug Weinstein said it. He was like, look, we're drafting this, prepping this motion just in case so that we can respond quickly. If they do one thing, we can respond quickly. If they do another thing, we can respond quickly. So they are anticipating. Oh, it's a gifter level. Thank you, Jamie. Okay, it's a gifter level. Appreciate it, Alicia. Got it. Okay, I was trying to figure out what that meant. All right. But yeah, so they're not wrong for asking that. I don't think that's a crazy ask at this point. I probably would have put in there, and maybe he did. Let me just keep reading and see if he put it in there. Undersigned counsel needs to cross-examine all the parties to ensure that the sworn testimony is spread in open court and on the record. So I probably would have put in there, but it's hard to keep up. It's hard for me to keep up, and I'm not there. I'm sure it's hard to keep up with everything, but I distinctly remember that Arkellian Bennett was also arrested related to, her testimony and whatnot. So I don't think it's a hard ask or a bad ask for them to ask that. All right. Mr. Williams' trial is constitutionally broken based on the unconscionable misconduct. Ooh, unconscionable. I love descriptive words. Unconscionable misconduct of Judge Glanville, Lori Love, and Lori Hilton, all working together in an effort to convict Mr. Williams. Y'all, this is aggressive. This is aggressive. It's aggressive. And I personally, I don't think that we have seen behavior from Judge Glanville that makes me think that he's like intentionally corrupt and he is doing this in an effort to make sure that Young Thug is convicted. I don't think we've seen that kind of like malicious type behavior. I think what we have seen though is, the point is, it should not matter. It should not matter whether or not it's intentional. All that matters is that it happened. So I personally would be lacing these motions with those kind of arguments as well. It does not have to be malicious, right? The behavior doesn't have to be malicious. It just has to occur. He did. He said that he believes that they have proven the conspiracy. So there's a fine line there, right? So there's certain thresholds in RICO cases and in a lot of cases that the defense will say, Judge, this piece of evidence can't come in until they establish this, right? So the judge kind of has to make some threshold rulings based on evidence that they want to come in. So when he's saying they've proved the conspiracy, and wait, I don't know if he said they've proved the conspiracy so much as he said, hold on, I'm rehearing what he's been saying in my head. I don't remember if he exactly said they proved the conspiracy, but something to that extent. He definitely has been repeating, mirroring, they've proven X, or they've put forth enough evidence to establish, right? Proven is for the jury. The jury only decides what's been proven, but the judge can say there's been enough evidence to establish XYZ or for it to go to the jury, right? And actually, and I hope we get a chance to see this, it's a really actually cool part of any trial. At the end of the state's case, you'll hear motions from the defense attorneys. They'll make them no matter what happens, but these are motions where basically the defense will say, listen, they haven't even put forth enough evidence for this to go to the jury. So you as the judge should not put this in front of the jury, because as a matter of law, what they put in front of us was not enough, right? So this element of the crime, for example, it's just not there. They haven't put forth one piece of evidence to show that it's there. So you as the judge should say that he's not guilty based on the law before, any facts go to the jury. So we'll get an opportunity, hopefully, maybe we will, maybe we won't, who knows, but we should get an opportunity to hear those motions. And so that's kind of what he's referring to. Like, yeah, they've established X, they've established that threshold, is what he's saying. Could Woody still plead the fifth since it doesn't apply to certain crimes? So the only crimes it doesn't apply to are, I would assume, new crimes. Of course, crimes that are unrelated to this, right? So he's not going to be able to confess that he murdered somebody unrelated to this conspiracy, or he's done something that's unrelated to this. It's not immunity. It is immunity for what he testifies to in this case, point blank period, right? But it's not the kind of blanket immunity that's going to allow him to say, I don't even want to say that he's committed crimes that are unrelated to this. It also is not going to allow him to lie about, it should not, because he can still be prosecuted for perjury. In fact, that's the only kind of fail-safe that they have if they're able to prosecute him for perjury. Now, will they prosecute him for perjury? I don't think so. I don't think so, unless he doesn't testify unless he says something contrary to what he's already said. Right. They know he's lying. Can they prove he's lying? Woody is not crazy. Woody said before he ever took the stand, I already lied. I lied to them. What he's doing is basically saying, you can't prosecute me for lying because you don't know what's the truth. That's what he's saying. They know he's lying because he's been lying. So, but from their perspective, he's lying if he's not saying what he told them before, because what he told them before was helpful to them. So from their perspective, what you said the first time was the truth, and if you say anything different now, it's a lie. That's basically their perspective. That's essentially what, Miss Hilton, because I don't think Miss Love was in there when they were discussing it, but that's basically what Miss Hilton said. We know what you've already said, and which is what they wanted. So yeah. But all right, back to the motion. The criminal justice system in Fulton County in the state of Georgia and in America has been attacked by the conduct of these three actors. Whew. He's making it a broader. He's saying the entire criminal justice system is at risk. The injustice must end immediately, beginning with Judge Glanville removed and disqualified from Mr. Williams' case. Thereafter, this motion is also timely made for Lawyer Love and Lawyer Hilton to be removed and disqualified from Mr. Williams' trial, and the Fulton County District Attorney's Office must be investigated for their improper conduct, if any, outside of the actions of Lawyer Love and Lawyer Hilton. He said burn it all down. He said burn it all down. They all lie. They all cheat. Do I think it can be a federal case, being that the state has done such a poor job? No, not this. I mean, could they potentially try to bring forth a federal RICO? That would be a separate case, right? So not every crime that's a state crime is a federal crime. Not every crime that's committed in the state can become a federal crime. The feds don't just pick up a case. Don't just pick up any case. First, they're very particular about the cases that they pick up, but the state RICO Act is different than the federal RICO Act. So they would need to establish, and quite frankly, I don't think they have enough to establish the state RICO, let alone a federal one, but they would need, the feds would need to see that there is sufficient evidence for federal RICO violations, not just the Georgia state RICO violation. Why they went in so prematurely, the state. So this is not premature. They've been dealing with this for like 10 years. They have been, I don't know at what point they thought they were going to make it a RICO case, but they were investigating this since 2014, 2015 or so, and they didn't get indicted until 2022. So it wasn't, it was thorough when it comes to time. I don't know if they ever got enough. I don't even want to say it wasn't thorough when it comes to the actual investigation, but just because they were thorough does not mean they actually got enough evidence. No, they're prosecuting it because they were told to. You know, there was somebody at a certain level of prosecution. Is just, this is a case that was brought before us, and we're bringing it forward, right? So I don't think that Ms. Hilton can say we're dismissing this case, right? Especially not this kind of case. They probably need some serious upper level approval to do that. I think Ms. Love is the deputy district attorney, so I don't know. Why didn't the prior DA prosecute? I don't know if maybe they weren't planning to prosecute and they just didn't because, you know, the timing. They didn't get enough evidence and enough time. That could have been it. So, Quinn, there is a saying that grand jury could indict a ham sandwich, right? That's all you need to indict in a grand jury, whatever the saying is. You only need this much. You only need this much, right? They have enough for probable cause. They have enough to indict. But the difference between an indictment and a conviction is a whole bunch of stuff. There's a lot of evidence and a lot of convincing between a basic indictment or probable cause to bring forth charges or to arrest in an actual conviction. So yeah, and we'll never know because they're private. So we will never know. But yeah. Alright, back to the motion. Judges must scrupulously avoid improper ex parte communications whether or not they consider them. A judge has the ethical duty to recuse himself sua sponte anytime a judge is aware of grounds to do so. Sua sponte just means on his own or on her own. So anytime a judge becomes aware of a reason they should not be on a case, they should recuse themselves without any provocation, without any request. They should just do it. Judge Glanville did the opposite of recusing himself sua sponte, even though he is keenly aware that helping Lawyer Love and Lawyer Hilton to influence Mr. Copeland to change his mind and testify against Mr. Williams is not permitted by any judge in any court. Instead, Judge Glanville, the Chief Judge of the Superior Court of Fulton County, Georgia, has taken upon himself, at the behest and encouragement of Lawyers Love and Hilton, to ally himself with the prosecutors in this case. Judge Glanville's misconduct shall not stand. Ooh. The law must be followed. Judge Glanville must be recused and disqualified from Ms. Williams' case instanter. So, here's the thing about perception. If Judge Glanville, believes that what he did was proper, then he's not gonna recuse himself sua sponte, because he doesn't think that he did anything wrong. And I think that's fine. I think that's okay, because sometimes we need another person to show us from another perspective what the problem is. So I'm okay that he didn't say, damn, you know, when he left the ex parte meeting, he didn't say, damn, I shouldn't have had that meeting, let me just go ahead and recuse myself. I'm cool with that. What I'm not cool with is the way that he attempted to protect the proceeding, the ex parte proceeding, for weeks after it was discovered. Okay. No hearing is actually needed to reach the finding that recusal of Judge Glanville instanter is mandated. Judge Glanville has automatically caused his recusal and disqualification from Mr. Williams' case by unlawfully becoming actively involved when he presented argument refuting Affiant's allegations of judicial bias. Another YouTube link. So what he's saying is, this goes back to, and the standard is the same in Florida, if there are factual allegations that, if true, they are sufficient for recusal, you should recuse yourself. The judge is not supposed to refute the allegations, right? They might not be true. They could be completely false. The point is that another judge should determine those, right? He should not be arguing back and forth about whether or not it happened. His instinct was to defend himself, and he's saying that automatically disqualifies him. If this honorable court disagrees, Mr. Williams respectfully requests a hearing, as he will call Judge Glanville, Lawyer Love, and Lawyer Hilton as witnesses to fully unmask this above discussed misconduct, as well as further misconduct that may have occurred. Hey, Eva. All right. This judicial and prosecutorial misconduct denotes, a disgraceful episode in Fulton County courts. The Fulton County District Attorney's Office and stains courts throughout the state of Georgia and our country. What occurred in this star chamber, outside of the view of the cameras, in the shadows and hidden from Mr. Williams and his counsel and the public, is unpardonable, and all in violation of Mr. Williams's constitutional rights stated herein, as well as in Exhibit A. Y'all, he is condemning the fuck out of them. He is condemning them aggressively. Like, every other sentence is a brand new adjective about how trash this meeting was. He is aggressively condemning them, y'all. All right. Anybody that's watching, let me see. Let me do this. I see people do this all the time. I have 500 plus people watching now. If you don't already follow me, please do. I enjoy making this content. For anybody who does not already know, who just kind of joined in, my name is Arian. I am a criminal defense attorney in Miami, Florida. I own White House Law Group, where I am the only attorney. I am the sole attorney. And this is what I love. This is what I enjoy doing. These cases are super exciting to me. So I watch them when I can. And yeah, I like to produce this kind of content. So if this is what you're interested in, go ahead and follow me. If you are watching from YouTube, please go ahead and subscribe. I'm sorry if you're watching from YouTube. I cannot see your comments. I'm new to this, so I can't figure out how to see both comments yet. But if you're on TikTok, I can see your comments. Thank you, the NK Show and Michelle Phillips. But yeah, so go ahead and follow me if you are not already following me, and I am thoroughly following this trial, so I will be updating as new things occur. All right. And for anybody who wasn't here at the beginning, what we're reading now is the motion to recuse. We're not going to read the entire thing. It's 233 pages. We're just kind of going through the actual arguments. And Brian Steele is laying Judge Glanville, Miss Love, and Miss Hilton like, oh God. He's reading them for filth in every other sentence. Very serious accusations, very aggressive accusations. Some of them very colorful. And again, I am not representing Young Thug in this case. If I were his attorney, I would probably feel as strongly as Brian Steele does, because he's in it. But from the outside looking in, I think it's super colorful, right? It's probably more colorful than I think what's actually going on. I don't think that Judge Glanville is, attempting to make sure that Young Thug is found guilty. But I get what he's saying, and this is how you have to advocate for your clients. But it's a fine line, right? There's plenty of judges that will read motions and say you did too much, and now I can't take you seriously. Now I'm questioning your credibility because I reviewed everything and nothing that you said happened. It didn't happen that way. Now I don't think that's what's going to happen here, because I think this ex parte meeting was egregious in the sense that here we are 3-4 weeks later, still dealing with the response to it, and it just should have never happened. Nothing they discussed in that meeting couldn't have been discussed in open court. So yeah. So he said the judicial and prosecutorial misconduct denotes a disgraceful episode in Fulton County courts, the Fulton County District Attorney's Office, and stains courts throughout the state of Georgia and our country. What occurred in the Star Chamber outside of the view of the cameras, in the shadows, and hidden from Mr. Williams and his counsel and the public is unpardonable and all in violation of Mr. Williams' constitutional rights stated herein, as well as in Exhibit A. Judge Glanville, Lawyer Love, and Lawyer Hilton have created secret Star Chamber proceedings in which the state of Georgia has promised its citizens would never engage. So apparently this is the case addressing this very type of meeting. As the Honorable Supreme Court of Georgia has taught, justice faces its greatest threat when courts dispense it secretly. Our system abhors Star Chamber proceedings with good reason. And he can't say it enough, because having an ex parte meeting in a criminal proceeding requires extremity. It's not something that just should happen, hey, the state wanted to have a meeting to talk to this guy. It shouldn't be happening like that. It should be rare. It is frowned upon, and it just shouldn't be happening unless it's absolutely necessary. And I really don't see where it was absolutely necessary in here, other than Ms. Love feeling some way about Melnick. Judge Glanville, Lawyer Love, and Lawyer Hilton have teamed up to conduct their illegal and unethical conduct outside of the view of Mr. Williams and his counsel, the public, and outside of the lens of the cameras. These public officials shall never be trusted by Mr. Williams or undersigned counsel. Oh my Jesus. Why did anyone that's higher than Judge Glanville intervene when the meeting occurred? Because there's a chain of command. The motions have to be made. They were made. Judge Glanville blocked them, and then Doug Weinstein went to the Supreme Court, and the Supreme Court said, no, Judge Glanville can't hear it. It has to go to somebody else, basically. But Brian still said, I'll never trust any of them ever again. I mean, I'm going to leave that there. There are serious consequences for these intentional and unjustified misdeeds that have not yet been dispensed. The clear evidence is that Judge Glanville is not impartial, and or there is at least the appearance that Judge Glanville is not impartial, and that's all you need is the appearance. Judge Glanville must be removed, disqualified instanter from Mr. Williams' case. As sworn to in Exhibit A, Judge Glanville, Lori Love, and Lori Hilton conspired. Conspiracy and a conspiracy to conceal and suppress Brady material. To suppress Brady material is what this is saying. Brady evidence. This Star Chamber cannot prohibit Brady evidence from coming forward. That is exactly what Judge Glanville, Lawyer Love, and Lori Hilton planned to do. Mr. Williams' constitutional right to due process, a fair tribunal, a fair trial, effective assistance of counsel, right to cross-examine, right to see, hear, and be present for the statements of a sworn witness have been obliterated by Judge Glanville and his cohorts. Judge Glanville must be removed as he has forfeited his position as judge. The June 10th, 2024 Star Chamber meeting between Judge Glanville and Lawyers Love and Hilton undermined the public's faith in the integrity of the justice system as it conceals from the public Mr. Williams, his lawyers, and the others facing the removal of their liberty critical information about the lawfulness and reality of how they are being prosecuted. This injustice must end today. This trial is wholly broken and cannot ever be repaired based solely upon the improper conduct. Dang, he said, y'all ruined the whole trial. Based upon the improper conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton. Any motion for mistrial made by Mr. Williams is based exclusively upon the improper actions of the supposed judge and state actors. Let's see. All right. Judge Glanville, at the indecorous Star Chamber ex parte meeting, provided legal advice and direction to Attorney Bumpus about how to speak to her client, Mr. Copeland. Dispensing legal advice creates a clear appearance of partiality, which is a proper ground for the granting of this motion to recuse under our Code of Judicial Conduct and a constitutional violation of due process. There's a thin line there. I think the judge is, first and foremost, if the judge is the person holding him in contempt, the judge can explain what contempt he's being held in, what the penalties of that contempt are. I don't think that's a problem. I think he's going into the whole, you print out the statute. I think he's going into some of the ad-libs that Judge Glanville was given during the meeting while Hilton was talking to him. But I don't think that him discussing in general contempt and what it is a problem. I think the bigger problem is that it was done ex parte. Mr. Williams' constitutional right to due process has been violated because not only is there an appearance of partiality, but there's actual bias, as Judge Glanville has been embroiled in this trial and is assisting the prosecution to attempt to gain a conviction of Mr. Williams. It's impossible for any reasonable person to believe that Judge Glanville is neutral. Judge Glanville must be removed based upon the one ex parte communication that has come to light thus far. Judge Glanville, Lawyers Love, and Hilton, he didn't even spell love with a capital L, Lord Jesus, I'm sure that was an error, but have infected the process of Mr. Williams' trial and have illegally poisoned sane forever. Let me see, did I miss anything? Alright. Judge Glanville had the ethical duty to recuse himself sua sponte. We read that already. We know that already. Neither of them uttered a word that they spent the morning of June 10th, 1, leaning on Mr. Copeland to testify, 2, coaching attorney Bumpus on what and how to sell Mr. Copeland the proposition to cause him to testify, 3, coaching Mr. Copeland on how to deliver his testimony. Now this is going to be important because there was a lot of time spent on how he could say what he could say, etc., etc. That conversation should have been solely between Bumpus and Mr. Copeland. I agree completely. Promising Mr. Copeland that he would not be prosecuted even for perjured testimony unless he told a bold-faced whopper lie. These public officials heard and failed to reveal that Mr. Copeland confessed to committing every indicted offense in this case. Even non-lawyers can see that Judge Glanville, Lawyer Love, and Lawyer Hilton are not acting in an ethical manner, are on the same prosecutorial team, and that Judge Glanville should not be rewarded with the opportunity to continue to preside as judge over Mr. Williams' jury trial. In reality, Judge Glanville, Lawyer Love, and Lawyer Hilton have made themselves witnesses, I agree, to a certain extent, to witnesses whom Mr. Williams' counsel will call. These 3 lawyers must be recused. He didn't even call them a judge no more. He said these 3 lawyers must be recused and removed from this case. Let me say this too. It's scary going up against a judge. Yes, so this is both. So this is essentially an amended or supplemental motion. And he kind of, it seems like he just put in there that Judge Krause should recuse herself in the amendment because of the donation. So far it's only been a footnote. If anybody else has already read it, because I haven't, let me know. But so far it only appears to be a footnote that he added to the motion that was already filed. That's my understanding. Jerica, that's the risky part, right? Do you go, and this is for the attorney, do you go super hard like Brian Steele is? Because what happens if we're all human? We're human. What happens if the motion is not granted and Judge Glanville continues to be on this case? Do we trust that Judge Glanville because quite frankly, generally his attitude is pretty mild. And maybe I'm biased because I've been in front of plenty of judges that are mad disrespectful right out the gate. His temperament is he's kind of mild mannered. He gets animated like anybody can, but so this motion, from my understanding, has been denied in part. My understanding is Judge Krause denied the motion based on the money that was donated, not based on any of the other arguments. So we have not heard Judge Krause respond to Doug Weinstein's motion to recuse her, which basically says nobody in Fulton County can hear this case. So we haven't heard that. So I don't think it's an outright denial. I think Judge Krause is just saying, I'm denying on these set of facts, this particular part of the motion. That's what I'm denying. That's my understanding. Okay, he's going into basically talking about how he denied the right to read the transcript. Yes, we're still waiting on the state. Still waiting on it. He initially denied the request for the transcript and hid it, Fortunately, mounting pressure related to Judge Glanville's gross misconduct, violation of his oath of office, ethical violations, and potential criminal conduct by Lawyer Love, Lawyer Hilton, and Judge Glanville worked to effect change. And that is probably the truest thing that I think we all can agree on, is that had there not been so much pressure, had this trial not been streamed on YouTube, had there not been public outcry for release of it, had there not been other lawyers like myself, like all the other lawyers commenting, because I'm sure the Fulton County DA's office, I'm sure Judge Glanville, I'm sure they watched some of this stuff. Had people not been outraged by what was going on, I think it might have taken a much longer time, or maybe never. Because remember, his thing was appeal it. Just appeal it after the conviction, essentially, if that happens. I think it's clear that it was the public outcry and the response by the public and social media or whatnot, and the judges and the defense attorneys that filed incessant motions over and over again to get this transcript and to get this information out in the public, that pressured him into doing it. I truly believe that. On Monday, June 17th, Judge Glanville denied undersigned's counsel his motion to recuse and went forward with the trial of the case. Similarly, Judge Glanville denied the Honorable Douglas Weinstein's motion to recuse on June 12th. Gosh, y'all, it's been a month. What's today? Tomorrow makes a month since this meeting. I just gotta take that in real quick. In a case that is already expected to last another year, we spent a month, a whole damn month, arguing about an ex parte meeting that should never happen. No, so not that group. So I'm practicing in Florida only right now. I went to law school in Georgia, but I practice only in Florida. I'm in, the easiest way to explain it, so there's a Georgia Association of Criminal Defense Lawyers, that's the group that showed up. There's also a Florida Association of Criminal Defense Lawyers. So I'm in the Florida group. I'm a member of the group. I'm not in the Georgia one because I'm not a Georgia lawyer at this point. It's not right now. But I will say the type of camaraderie and collective effort by the Georgia defense lawyers, that defense bar, is very similar in Florida. Very similar. We share a lot of information and, help each other out in the same sort of way. I suspect if something like that happened in Florida, we would get the same response. I'm almost certain of it. All right. All right, so he's going back into talking about how he hasn't been able to question Ms. Love. Apparently, Ms. Love gave Woody a list of questions that he was going to ask. The undersigned counsel has never been given this list of questions, even though Judge Glanville has made aware of these questions and has encouraged Attorney Bumpus and Mr. Copeland to review and understand these questions. And I don't think he's entitled to get the questions. That sounds like work product to me. If you are calling a witness, you can prep that witness. So you can have conversations with that witness. You can talk to them, get more information from them. You can let them know what you're going to ask them about. You can't instruct them on how to answer it, but you can. So I don't think that they're entitled to get, Ms. Love's or whoever's going to question him, their thoughts on what questions they're going to ask. I just don't. But hey, while you're going for it, go for it all. So. All right. Judge Glanville, Lawyer Hilton, and Lawyer Love did not give a hint that they were meeting ex parte with witness Copeland on the morning of Monday, June 10th, or at any time. Undersigned had no idea. Of course, none of us did. We all were waiting and watching. I was too. No idea that they would dodge the law and the ethical rules to conduct this improper and unethical ex parte conference. They were duty bound to immediately announce I mean, I think they were duty bound to not have the meeting. But if they had the ex parte meeting, they didn't think you had a right to be there for whatever reason. Why would they announce it, right? That kind of defeats the purpose of the ex parte meeting. The point of the meeting was so that you would know. That's the whole point of it. So yeah. But I agree. Once Brady material was discovered, there shouldn't have been a question. Once he said anything that was Brady material, and he said plenty that was Brady material, the meeting should have been disclosed at that point. I agree. All right, they were acting. We get it. They were teammates acting in concert, and they hid Brady evidence. All right. I'm just kind of skimming through. They intend to call Judge Glanville as a witness. We know that too. He's become a necessary witness in Mr. Williams' trial, and his name will be used when the undersigned cross-examines Mr. Copeland. And this is going to be a problem. This is going to be a big problem because they can't stop him from asking Woody, oh, remember that meeting you had with Judge Glanville when I wasn't there? And what do y'all think Woody's going to say when he asks, were you pressured to say XYZ, 1, 2, 3? Were you pressured to testify? They can't stop. And now the jury's going to be like, what meeting? They had a meeting without the defense? Wait, so that's why we haven't been in trial in 2 months? Because of this meeting? It's going to cause a problem. It's going to cause a problem. An example of Brady material. So, Brady material is any piece of evidence, whether it be words like testimony or written statements. It can be a written statement. It can be physical evidence. It can be videos. Anything that tends to show the innocence of the defendant. It doesn't have to be explicit, right? So it doesn't have to be a video that shows another person committing the murder. So when they say it tends to show the innocence, it just diminishes the state's case. It has a negative effect on the state's case and a positive effect on the defendant's case. So for example, the fact that Woody has previously lied, that's Brady material because when he testifies negatively about Young Thug or about YSL in general, they're able to impeach him and say, but you lied before. So that's not direct evidence saying that Young Thug is innocent, but it dampens the credibility of Woody. So anything that is related to the credibility of a witness, if it affects them negatively, that's Brady material. If they change their testimony, that's Brady material. Or anything that can be shown to demonstrate or that can be positive for the defense's case is the easiest way I can explain it. Yeah, they were not expecting him to be likable. Same with Tick, I think. I think they were not expecting Tick to be likable at all. And he was very likable. All right. Okay. All right, so this is basically going through the Georgia recusal law, which we kind of read earlier. Impartiality might reasonably be questioned. I told y'all earlier in the first part of the motion, that's likely the standard. This is what attorneys do. They mirror, when they make accusations in a motion, they mirror what the standard is, what the case law, what the law says it has to be. So whether or not the judge's impartiality might reasonably be questioned, and this is the definition, means a reasonable perception of lack of impartiality by the judge held by a fair-minded and impartial person based on the objective fact or reasonable inference. So would a reasonable person, not somebody who's super defense friendly, not somebody who's super state friendly, not somebody who, is irrational, but a reasonable, normal thinking person, would that person believe that this that this person was impartial, this judge was impartial. Or might question, would that person question whether or not Judge Glanville was being impartial? So any one of y'all in the comments, reasonably minded, a normal thinking person, matter of fact, drop a 100 if you think that Judge Glanville was impartial. Drop a 100 in my comments. Yes, D'Angelo White. Yep. And Adrian Bean. Adrian Bean was fun. He wasn't likable. He was getting on my nerves a little bit, but he was fun. I got a couple. Drop a 100 if you think that whether or not Judge Glanville is impartial is a reasonable question based on what we saw in this meeting. Yeah, I think a reasonably minded person could say, hold on, something is not right about this. Or we need to know more about this. Or why would he do it? And I think that's enough in this particular case. Maybe not every time. Because sometimes there's an explanation, a reasonable explanation. But I agree. Well, they don't. The problem is these witnesses benefited the state, and I'm answering Quinn's question. So how does the state benefit if these witnesses are not helping them? They were helping them before. The information and evidence that they got from them previously was helpful. That's the truth. But now they have to testify. It's not that helpful. And a lot of times the difference between what we think we have and what we see on paper, it might not translate in court. And I've had cases like that before where it looks bad. From even, talking to the client, like, I get it, this looks bad. But in order for them to get this across, right? And I'll give one example. I had a case, a really bad case, where people were seriously injured. And the state attorney's theory was that my client left and went and got a gun, basically, and came back to the scene, and that's when all this happened. The problem is there was no evidence that he didn't already have a weapon on him from the beginning of time. And I kind of pointed that out. Like, how are you going to establish that, right? So it might look like that. It might seem that way. But sometimes what we see and what our theories are can't translate into evidence because you have to be able to get it in. The state attorney's theories are not evidence. And we keep hearing the defense say that. State attorney's theories are not evidence. The evidence is evidence. So you got to be able to get it in. No, we didn't even get to the denial order. I'm about to go to it now, though. I'm about to go to it now. I just want to make sure I didn't miss anything. All right, so he's asking for an evidentiary hearing on this issue where he can call them as witnesses, basically. And then he's going back into, some of this stuff is repetitive, understandably, because there's so many different points to be made that it's kind of hard not to repeat yourself. And again, remember, these are not motions that they have an opportunity. These motions have to be filed within 5 days. These are not motions that they get months to create. So where they might have been able to make it a little smaller had they had a month. It has to kind of be put out there. All right, so then he's going through the exhibits, etc., etc., etc. All right. Yeah, so from what I can tell, forgive me if I'm wrong, but I'm going to move on from this motion. It looks like the whole Judge Krause, the money situation was just an added footnote, and they maybe added some additional exhibits. That's what I'm gathering. Number 43. All right, Jamie, let's go to it. Let's see. 43. Before the jury, Judge Glanville will be spoken about in terms of his work as a member. That damn Brian Steele. Brian Steele said, I'm going to call him a prosecutor. In terms of his work as a member of the prosecution team, Judge Glanville will be called as a witness by Mr. Williams. The law mandates Judge Glanville be removed from the presiding over Mr. Williams' case because he cannot be both a witness and a judge in our lawful criminal justice system. He can also not be a judge and a prosecutor, or a witness and a judge. It's all the same. A witness and a judge, a witness and a prosecutor, a judge and a prosecutor, a judge and a whatever. It can only be one. Judge Glanville has given Lawyer Love, Lawyer Hilton, the Honorable Attorney Bumpus, and witness Copeland legal advice. Mr. Williams' jurors need to understand who has been orchestrating this kangaroo court. Oh, Judge Glanville, Lawyer Hilton, and Lawyer Love should have separate and distinct roles in our criminal justice system. These distinctions between these roles, or the distinction between these roles, has been washed away in Mr. Williams' case. He said, I'm going to get up there and say he's the prosecutor. I'm going to get up there and say it. Y'all. Alright. So, anybody who's already read it, I don't know if there's anything else in it about the money, but it appears that this is mostly about the actual recusal. Whoa. Last paragraph. Save the best for last. The law also requires this honorable court to recuse. Public must believe in the absolute integrity. Now, let's say this. We already see the clear distinction in how he's talking, right? Remember, because Judge Glanville was, right, the Honorable Bumpus versus Lawyer Love. Remember, Ms. Love used to be the Honorable Ms. Love, too, at the beginning of this trial. My, how things have changed. Alright. That is why, even without a showing of actual bias, prejudice, or unfairness, and regardless of the merits and timeliness of any motion to recuse, it's inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits the same circuit. Supreme Court of Georgia observed that our Judicial Qualifications Commission, that's the JQC, has opined that a judge in a particular court should never preside over a matter concerning another judge from the same circuit. The Honorable Court of Appeals of Georgia has explained that, as cited above, the Commission concludes that it will be inappropriate for this Honorable Court to preside in this action where Judge Glanville holds a judicial office in this Honorable Court's same circuit. Therefore, under law, this Honorable Court must recuse from this case because refusing to do the same will permit questioning of this Honorable Court, something the court will not countenance. This court must recuse as well. An appearance of impropriety exists in situations in which reasonable minds might perceive that this Honorable Court's ability to carry out its responsibilities with impartiality and integrity or competence is impaired. Let me just talk about that real quick, right? Reasonable minds means it doesn't have to be absolutely true, but would a reasonable person, again, think that this judge would not be able to carry out its responsibilities with impartiality and integrity or competence, or whether or not that ability is impaired by the fact that they work in the same circuit. So we got a couple things going on. First, there's the donations, which apparently is $2,000 from Judge Glanville to Judge Krause. People donate to campaigns all the time. Maybe that's not a big deal. I'm actually more concerned about the fact that he's the head honcho in the Superior Court. This is somebody that she has to walk around and work with, daily. it is kind of complicated, right? Because what if her true feelings are, this was disgusting. This was the most trashiest, trash-ass ex parte meeting ever, and he needs to be read for theft, and I think he needs to be removed from the bench because I think he did it on purpose, and etc., etc. What if her actual opinion is super, super condemning? What if it's not a polite, I'm going to grant the defense's motion? Where does that put her? That puts her in a pickle, because now somebody who's not only donated to her campaign, but somebody who works with her, and someone who is essentially her supervisor or superior, if you will, somebody who handles and manages the courthouse that she works in, you know, that's complicated, right? That doesn't mean that she can't do it, right? It doesn't mean it at all. But would a reasonable person believe that it might be difficult for her to do it? It's not it's not like, oh my God, how could you say this about her? It's not one of those things, right? I don't think it's out of the realm of possibilities that it might be hard for her to make a decision like this. Well, Jerica, Brian still said, I'll never trust you again. You can't be trusted. So I haven't seen any cases I haven't seen anything in her courtroom, but that's good to know that she's open and you know, open-minded and fair. Okay. Furthermore, this honorable court has received a $2,000 donation. Oh, it's just like there on paper. To his re-election campaign from Judge Glanville in April. During the pendency of Mr. Williams' trial, Judge Glanville, giving this contribution for re-election, should be deemed an exceptionally large campaign contribution. He quoted that as though it comes from case law. I could tell you right now, I have no damn clue what will be considered large or not. But he's quoting it as though that number makes it exceptionally large. Let me find the case. So this case, Caperton versus A.T. Massey Coal Company, holding that exceptionally large campaign contributions may, in certain extreme facts, lead to constitutional due process violation by a judge's refusal to recuse. What does that amount? So is there a case that has a range or an amount? I don't know. Yeah, I'm not sure. All right, but that's the motion. Now we know it was denied. We know it was denied. Let's see. Right, I did read that much. She pretty much said, "It's so what? It wasn't even that big of a deal." Ooh. Jamie, I did not know that. Interesting. That's interesting. I'm going to see what I can find about that. Did not know. Okay. All right. So this is the order. All right. This case was randomly assigned to this court to consider certain motions to recuse. On July 8th, defendant Jeffrey Williams filed a supplement to motion to recuse. Though titled supplement, a portion of the filing seeks to recuse this court from hearing the recusal motion. This court, therefore, must consider the portion of the supplement seeking this court's recusal before proceeding further. So she's basically saying, I only want to address whether or not, so I'm not deciding on whether or not Judge Glanville needs to be recused, but because you want to recuse me, I need to decide whether I need to be recused. So now we're asking to recuse the recuser, and I need to know if I need to recuse myself. That's what she's saying. All right, that's not a juicy footnote. Let's get to the meat of it. All right, defendant Williams' motion in footnote 2 and later a lengthy paragraph 52 asserts two bases for recusal of this court. Defendant William asserts that recusal was merited because of a $2,000 donation made by Judge Glanville to this court's recent re-election campaign. Defendant Williams also asserts that recusal is required because it's inappropriate for any judge to preside in any action where one of the parties holds judicial office in any other court which sits in the same circuit. Defendant Williams' supplement seeking to recuse this court is supported by an affidavit, albeit only footnote 1 in paragraph 63, I think it's 53, but whatever, as to this court, and it was filed within 5 days of the court being assigned to handle this case, so she's saying it was filed timely. And there is an affidavit. Therefore, the first two criteria are satisfied, and the only consideration for the court is whether Judge Glanville's campaign donation warrants recusal. Georgia Supreme Court has held that the mere fact of a campaign contribution to a judge, even from a party to the case, does not warrant recusal where the contribution was not exceptionally large. Why is that important, y'all? So me and Jamie were actually talking about this earlier. These people donate to each other all the time. It's a thing, right? Like, you may have a person that you know, that you believe in. Yeah, her footnotes were definitely boring. Don't even want to read them. You may have a person that you believe in that was never a judge before that's now running from judge. It could be your coworker. It could be your classmate. It could be someone that you used to work with. It's not out of the ordinary that attorneys will support attorneys running for positions. So it quite frankly, in the same city, in the same county, it's not uncommon that you might be on the opposite side of somebody that you know, or somebody you've previously worked with, or somebody you have a personal relationship with. So if we had to recuse every judge who received a donation, like, these people get thousands of donations from probably mostly lawyers, we wouldn't have, nobody would be able to try anything. So it just kind of is what it is. So I guess the remedy is, what type of donation, what's the threat, how much of a donation was it? That's essentially what she's saying. Politics is definitely trash. Politics is trash. But yeah, so the mere fact that this person gave a donation doesn't mean you have to recuse yourself, especially where it's not a large donation. All right. Yada, 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 blah, blah, blah. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, an affidavit seeking recusal must allege additional facts demonstrating the need for recusal. So, what is the maximum? Let's see if she cites it. I'll keep reading and see if she cites it because I want to make a point. In summary, Rule 2.11A4 provides that if contributions made to a judicial candidate or to that candidate's campaign committee are permitted by the law and do not exceed the maximum allowable contribution. Girl, come on now, Judge Krause, really? I really gotta go to the website. Did anybody look this up? Did anybody look this up? What amount can buy influence? All right, so I'm on the website. Statewide candidates, all other candidates, state, local. So we're going to go with all other candidates. And the limits are $3,300 in the primary and general election and $1,800 in a runoff. So let's go with $3,300, so it's under the limit, right? And it says up here, if it's under the limit, there has to be another reason, an additional fact. What additional facts did Brian Steele allege? Let's see. So my folks on YouTube, I'm so sorry. I am so sorry. Please forgive me that I cannot see your comments, but the next time I go live, I will be able to, I promise. All right, so the additional facts that Brian Steele alleged were that this donation was given during the trial. I do think that's important. This is a recent donation that was given during the pendency of this trial. And I think probably an additional fact, but I don't know if he said it like that, is that he's the chief judge. He is a judge who they have to answer to, is not quite the word that I want to use, but in a roundabout way, he's the head lead judge in that courthouse. He sets standards, he sets policies for things that go on in the courthouse. His position is important and it matters. Those are basically his points. Those are Brian Steele's points. Yep. I agree, Jamie. So apparently some of the defense attorneys in the YSL case donated to Fonnie Willis's campaign her election. And so the question that Jamie had was essentially, is that a conflict? It could be if the client feels, essentially it's up to the client, right? So if the client is saying, I think this is a conflict, I don't think that you can represent me, they're entitled to waive it, right? The person who holds the conflict is the client. Like, it's their conflict, so they can waive it. They can say, I don't care about that. Like, I know how it goes, and I think you can still represent me. As long as you're not afraid to go forward and be aggressive, I don't care. Yeah. So I don't think it automatically creates a conflict, but for certain, if the client knows about it and the client thinks it's a conflict, it's a conflict. Okay. Defendant Williams's additional assertion of the JQC's opinion in support of his motion is unavailing for two important reasons. First, Judge Glanville is neither a party nor counsel in this criminal prosecution, nor is this a mandamus action. And Defendant Williams cannot make it so by filing a recusal motion. Okay. So Opinion 220's conclusion that a judge should not preside in an action where one of the parties holds a judicial office in the same circuit does not apply to this circumstance. That's also Doug Weinstein's argument. Second, and perhaps most importantly, Defendant Williams' motion ignores the clear directive of Uniform Superior Court Rule 25.4. That rule directs that in a multi-judge circuit, like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by one of the circuit's existing random impartial case assignment method. So she is saying that there are Georgia rules and law basically, because the rules are sometimes codified that way, that though that rule requires that it be randomly assigned to a Atlanta judge, a Fulton County judge, possibly. Now, here's what I don't know. Every city's different. I don't quite know how their circuits are broken up. So, like, for example, in Miami, Miami has its own circuit. We're the 11th circuit, and then Broward is like the 17th circuit. So I'm not sure how their circuits are broken up. It sounds like Atlanta itself is a circuit, as opposed to Fulton County, DeKalb County, Cobb County, etc., which I believe pieces of Atlanta. Anybody from Atlanta in the comments? Because I'm not exactly sure what a circuit is in Atlanta or in Georgia. Not 100% sure. Okay, so in Miami, there's no way to be in the 17th Judicial Circuit if you're in Miami, right? If you're in Miami, you're in the 11th Judicial Circuit, point blank, period. If you're in Miami, Miami-Dade County, or the city of Miami, you're in the 11th Judicial Circuit. If you are in Broward County, now Broward County has a couple other cities, so I don't know Miramar, Pembroke Pines, however they break down the cities. Those are all in Broward County, though, so they're all on the same circuit. So it's usually by county unless they're objected to. That makes the most sense to me because I believe counties, I believe the city of Atlanta there might be several counties in Atlanta. Maybe I'm wrong. I don't know. I never got comfortable with the map of Atlanta. But yeah, so maybe I'm wrong about that. But yeah, so Doug Weinstein did file a writ of mandamus. Now, let me keep it a buck with y'all. I probably need to go back and reread it. Atlanta Judicial Circuit is comprised of Metro Atlanta cities. So, remind me, please. So, Lisa, for example, is Decatur considered its own? Fulton County has multiple cities. Okay. Mamiana, I know that's not your name. Please tell me your name in the comments so I can actually call your name. I don't want to call you. Sometimes I can guess, but I can't guess. Jasmine. Okay. Thank you, Jasmine. So Fulton County has multiple cities in it. Okay. I'm gonna go back. I should be ashamed of myself. I lived in Atlanta for like almost 4 years, so I should know better, but Miami is on a very nice grid, so it's very easy to learn. Atlanta is a whole nother world. But okay, so Metro Atlanta cities, meaning Atlanta itself, I'm assuming, and then what other are there any other cities you can think, like, you can name that are there? Lisa, I'm sorry. Yeah, Atlanta is real confusing to me. Got it. Okay, so all of the counties are in that circuit, are in the same circuit. Got it. Okay. So Clayco, DeKalb County, Cobb County, Fulton County, those are all within the Atlanta Judicial Circuit. Got it. So if what Doug Weinstein and Brian Steele, portions of Dunwoody, okay. If what they are arguing, oh wait, James said no. Now I'm confused again. Don't confuse me, y'all. But if what Doug Weinstein, what they're arguing, the way that I'm interpreting it is that no one in any of those counties, because they're all in the same circuit, would be able to hear this case. It would have to be somebody outside of any of those counties. So, and I heard Doug Weinstein, if I'm not mistaken, say something about Savannah. I forgot what county that is, but yeah. So maybe that's the argument. They're not in the same circuit. So I'm gonna do a little homework. I'm gonna go back and look at a map of Atlanta so I can discuss this a little more intelligently next time. But essentially, that's what it sounds like he's saying, that nobody in DeKalb, Cobb, Fulton, Clayco, or Dunwoody. Oh, Dunwoody is a part of Fulton County, so I'm missing one. There's a big one that I'm missing. Douglas? Henry. And what about Douglas? Is that Douglas does that count? Oh, Gwinnett. That's what I was missing. Okay. But yeah, so it sounds like that's the argument, that none of those judges in any of those counties will be able to hear this motion. Which is there are probably judges in those counties that don't even know each other, right? Across those counties. So that's a big group of people. And so it just naturally seems like it would be a little bit extreme. It will require some kind of extreme circumstance for that to be true. So I'll go back a little bit and look at Doug Weinstein's and confirm. Judicial canon rule that disallows any judge from the same circuit to hear the case, which makes sense because they're they interact with each other, right? But given how big Atlanta is, there might be judges that don't like. There would it be impossible to find a judge that could be impartial in Atlanta? No, not if it's comprised of Gwinnett, Cobb, DeKalb, Henry. Like, I don't think it will be impossible. Will the outside judge have to come to Fulton? No, because this is not going to be the judge that's hearing the case. This is just going to be the judge that's determining whether or not Judge Glanville is recused. So if Judge Glanville is recused, it's going to go to another judge in Fulton County. This is just about who can hear the recusal motion. That's the only thing they're talking about, which is crazy when you think about it. We're not even at the point where we know there'll be a new judge. All right. So she's basically saying this is not a writ of mandamus. And it's not a writ of mandamus because she hasn't refused to do anything. They're not asking her to be forced to do it because she hasn't not done it, right? So the writ of mandamus with Judge Glanville came because after 50, 11 times of them asking him to send the recusal motion to another person, he didn't do it. This is the first set of motions, so it's not a writ of mandamus. All right. And then she also basically says that with the rule that it conflicts with the actual rule, which says that it shall be randomly assigned using the circuit's existing random impartial case assignment method. So, the court does not relish the task to which it has been assigned. Fair. Judge Krause has a tough responsibility in front of her. Atlanta is viewed as liberal against the other conservative counties. Absolutely. My time in Georgia, if it taught me nothing, my time in Georgia taught me that Atlanta, the bubble that Atlanta and maybe the little areas surrounding Atlanta are in are very, very different from Georgia as a whole. Yeah, the experience in Atlanta is completely different. No different than, kind of Miami. Miami is not super duper liberal, but comparatively speaking, there are parts of Florida that you might think you were in Alabama, you might think you were in Louisiana, you might think you were, in a very conservative place. So, yeah. If I didn't learn anything else in Georgia, I learned that Atlanta is different. This court does not relish the task to which has been assigned. It is as much the duty of a judge not to grant the motion to recuse when the motion is legally insufficient. That's nice. As it is to recuse when the motion is meritorious. For the foregoing reasons, the portion of defendant Williams' supplement and amended supplement seeking to recuse this court is hereby denied. Okay, so she denied it. Yeah, she said that's it. I've been seeing people say that, Jasmine, that Fulton of the other counties is more conservative. I've been seeing people say that. Not necessarily attorneys, but I have been seeing people in general in comments in other places saying that. So, yeah. Yep. Alright, so that is pretty much it as far as the motions. So, let me say this, Jerica. He is super decorated and very accomplished as an attorney and as a judge, is my understanding. I am not of the opinion that he is corrupt and, I'm not of that opinion. I don't think that he's intentionally trying to ruin I don't think that. I think that his decisions are colored by the camera, which is, it's not even a slight to him. Of course they are. Everybody's is. There are cameras and it's being streamed by millions of people. Right. His problem is his ego. I don't think that he is corrupt and intentionally doing anything. I think that every time that I have seen that I've been like, whoa, what is going on? It is a response. It's him reacting to being called out about something or somebody disagreeing. And this whole ex parte thing, yeah, I'm shocked that it took this. But we have to remember, judges are not superhumans. They are human beings with egos, with emotions, with feelings, with pride. And I think that this whole ex parte post the meeting situation, I think that it was not evaluated wholly. Okay, Lisa said same. He's not corrupt in my opinion. Yeah, I think that it was not evaluated wholly. I don't think that anybody said, whoa, wait, he's already been sworn in as a witness. And I think had that tiny bit of information been in everyone's head at the time, they wouldn't have had that meeting. I don't think they would have had that meeting at all. I think that they didn't think about it. And again, we're all human. Woody hadn't said a damn thing on the stand at this point. So when we say he was a sworn witness, what we mean is just literally he was sworn. He hadn't said anything. Nothing. Not his age. He had told us how old he was, his birthday, nothing. So it's literally the fact that he was sworn. It's not that he's given any information. So, to be fair, I could understand how it wasn't a huge consideration because he hadn't given any testimony. But I think that's what changes this. Grown, right, Jamie? Grown, adult. I think he's here. Let's go see. Wait, when? What are you talking about, Jamie? I mean, Jerica. Marie said, is double jeopardy an option for this case? Not now. So double jeopardy is complicated. For the most part, it does not attach when there's a mistrial. So I don't see any risk of double jeopardy right now. If there were to be a mistrial, I don't see that. Yeah, there are people that go to trial 2 times, 3 times, 4 times. I don't know if y'all saw the I can't remember his name. It was like a 16-year-old guy. His in Texas. His mom and dad were murdered, and they thought he did it. Other people thought maybe his older brother did it. He went to trial like 3 or 4 times, if I'm not mistaken. So it's not, double jeopardy doesn't attach just because you went to trial. There are specific, circumstances where it attaches. For the most part, a mistrial does not mean that you're risking double jeopardy. Could he be a mistrial with prejudice? I don't see where that could happen. Because, again, unless we uncover some kind of prosecutorial, actual, physical, malicious, intentional prosecutorial misconduct, I don't see it. The one in Georgia, I can't remember his name right now. They had like 4 different, Quinn, the one in Texas. He was in Texas. They had like 4 different series, different documentaries about him, but I cannot remember his name at all. But he was really, really young, like 15 or 16 when it happened. It was some, some weird stuff going on. I think it was him and his little sister in the house. Yeah. Did they initially meet with the intention of bringing Woody in the room? You mean prior to the ex parte meeting? So Woody would have been in the room the whole time except he was coming from the jail. So the only reason the way I read it, the only reason Woody was not in the room is because he had to be escorted from the jail initially. And then once he got there, they brought him in. So I think the intention was always to bring him in. Is the ex parte meeting enough for misconduct? If it's painted the way that Brian Steele paints it, yes, right? If Brian Steele has it his way, yes, but I don't see it that way. I don't think there's enough to establish that especially after reading the transcript. There was bad stuff in there, don't get me wrong. But after reading it, I don't see the sneaky, conniving, like I'm standing over him with, and that is also a problem because again, we're reading a transcript. We were not there. We don't know what eyes were exchanged, what looks were exchanged, what was said off the record, etc., etc. But I haven't come across something yet that makes me say, this is intentional, malicious misconduct. Wrong? Yes. Absolutely. AJ Armstrong. That's his name. Thank you, Queen. Yes, he did. Brian still painted a Picasso of misconduct. Yes, he did. Woody is going to say, I felt pressured. I didn't want to testify. I wasn't going to testify. I said I wasn't going to testify. I said I was willing to stay in jail for however long. And then they started hammering me, telling me about, this person, that person, etc., etc. Woody, you could tell in his live videos when Kayla is asking, he's like, you know what they did. You know what they said. Yeah, y'all. I think Woody is going to testify favorably for the defense when he's questioned about the ex parte meeting. Absolutely. Absolutely. But yeah. So I think I'm going to go ahead and wrap up for tonight. There's still plenty to discuss and learn. Next, I think we are waiting on the response from the state. They asked for 48 hours, so it should be due tomorrow by 5. So assuming we get it tomorrow by 5, I will probably go live, depending on how long it is. If it's short enough, maybe I'll just make a video and post it, but we shall see. Oh gosh, get back. I was dying for him to explain that. I didn't want to laugh. It was definitely funny, but I didn't want to laugh. So I think any of the jurors have been I want to believe that they are being responsible. I don't think that anything in particular about this situation, other than the time, would make them any more interested in figuring out what's going on in the rest of the trial. Like, the whole trial has been sensational. So if they want to look, they have already looked. But, there's, who knows? We don't really know. We really don't know. Do I think they personally looked? I'm just going to say I hope they didn't. I hope they did. But, again, we're all human. We're all human. Who knows? We don't know. We could never know. Unless they get caught doing it, we would never know. Yeah. I hope they didn't, but I could imagine they want to real bad. He said, they did. Oh, man. This is different, y'all. This is the longest case in the history of Georgia. I don't think Florida has ever had a case this long either, as far as I know. And, telling somebody not to look, not to do it for a week, maybe 2 weeks, maybe even a month. But it's been a long time. It's been a long time. It's been a long time. And forget intentionally looking. What about just scrolling on social media? What about just scrolling on social media? Like 90% of, the people that find my page are just on the For You page. So they might not even be looking for it. Literally, everybody is talking about this case. So I don't know, y'all. I don't know. So I would hope they didn't, because we want fairness. So I would hope they didn't, but I wouldn't be surprised if they did. Yeah. I wouldn't be surprised. But yeah, so I'm going to wrap it up for tonight. It was great talking with y'all. Again, my name is Arian White. I am a criminal defense attorney here in Miami, Florida, owner of White House Law Group. This, of course, was not legal advice, but if you are in need of a criminal defense attorney, please email White House Law Group at info@whitehouselawgroup.com. I look forward to chatting with y'all on another day about this case and other cases. You can follow me on Instagram, TikTok, and subscribe to my YouTube. The name is the exact same on all platforms. E.S.QUIRED, E.S.QUIRED. I really appreciate y'all. I really, really do. Y'all have a great night. Be safe. And if you find any cases or legal things or just information about what's going on in the world that you're interested in and would like me to talk about, please feel free to DM it to me. I do my best to check my DMs. So yeah, like I said, it was great chatting with y'all. Y'all have a wonderful night. Okay, Jasmine, I'll check. I definitely will. Y'all have a great night. Be safe out there.